Hello and welcome. This is Professor Gera Puhol from UCF, and we will continue our short videos on contracts, and then I'll talk about fraud. So far we've seen that in order to show legally, right, a legally enforceable promise, legally enforceable contract, you've got to show four elements. That there was, consideration given by both parties, something of value promised or given in exchange for the promise made by each party, that there was an offer and acceptance that was voluntarily made, again, by both parties, that there was a capacity, the parties being of legal age and sound mind, and that the contract itself be for a valid purpose. Now, assuming we do have a legally enforceable contract, and in some cases the contracts do need to be in writing to be legally enforceable, as we saw in my first contract video with statute of frauds and UCC, those specific examples where a promise has to be in writing. But whether it's in writing or not, those four elements have to be met. Now, if a promise is made and the promise is not kept, now we could talk about remedies. And this is a fairly complex area of law, so I just want to simplify it. Since we're talking here survey course, I want to introduce you here to the Law of Contract Remedies. So when there's a legally enforceable contract, and that promise has been broken, there's been a breach of contract, then courts have a couple of broad options. One possibility is specific performance. Well, the court, and you would think with your common sense, this would be a common remedy, right? Where the court will order the other party, the party in breach, the party who's broken his or her promise, right? Hey, you have to keep your word. You have to do what you say you were going to do. In fact, specific performance is very rarely given, only in some very specific subset of cases where no other remedy really is practicable. The general remedy that courts give for a breach of contract is what lawyers call damages. And damage is just fancy word for money. Hence, I have the dollar sign right below. And here, the general formula is that courts will say, okay, what would have happened if the promise had been kept? How much profit, how much money would the parties have made if the promise had not been broken? And then courts will try to estimate that and then try to award that amount of damages. Now, as you can imagine, in practice, actually figuring out what those quote-unquote expectation losses are can be very difficult and very complex. It's very fact-dependent, depends on the context. I have a dear friend, Victor Goldberg at Columbia Law School up in their Upper West Side. He's written a lot about this topic. It's really fascinating, if you love contracts and contract remedies, but because this is an intro course, survey course, we won't go into all those details, just to note that courts have this broad option. And that's what I really want to focus on. And if you think about it, and by the way, the idea that specific performance is rarely given has been criticized. There are scholars out there that say, no, specific performance is really a better remedy to give. But I think you can see in the Winklevoss case, right, with Zuckerberg, why specific performance is so rarely granted. Because imagine if the Winklevoss twins were able to prove the existence of a legally binding contract. What should their damages be? And, or what should the remedy be? With specific performance, that would mean the court ordering Zuckerberg, who's now in charge of this thriving Facebook website, right, Facebook business, to stop what he's doing and then finish the website, presumably work for the Winklevoss twins. You can see that's sort of a recipe for disaster. That's just not going to work out very well. So their courts say, well, let's see, okay, let's try to then estimate monetary damages. Now, I will say, in fairness, right, estimating monetary damages, how much would the Winklevoss twins had made if ConnectU or Harvard Connection had launched first? That seems to be very speculative, right? But the main point here, I just want to introduce these two major types of contract remedies that potentially courts can order. All right, in our next video, we'll talk about the other major allegation the Winklevoss twins make, and that is of fraud.